Coming back to the land ordinance, Section 88 is critical. It's one section you know. No new title and no dealing with or claim or interest in any land except land still held under native customary tenure without documentary shall be valid until it has been registered. Section 88 is the hallmark of the torrent system of land registration. Basically, you cannot claim any interest unless that interest is registered. Meaning of term registration, as I mentioned to you earlier, Part 5 is one part where you have to go through in some detail and at least try to remember the purpose of each section. Section 89, every title shall be deemed to be registered under provisions and for the purpose of this ordinance, so soon as the same shall have been marked by the registrar with the volume and volume number so as to indicate its place, the register, and every dealing, this is the key part here, the second part, every dealing shall be so deemed to be registered as soon as a memorial thereof, as hereafter described, shall have been entered into the register. Okay, so this we are talking about the memorial number. Once the memorial number is issued, it will be deemed to be registered. Okay, we mentioned to you just now the process: MOT, presentation, memorial number, registration. Okay, titles in duplicate is another key provision of the torrent system of land registration. Separate register. Continuation of titles, basically, if your title run out of space, the registrar can actually add on a few more pages. This is actually continuation of titles. 96 talks about presentation. 97 talks about who can attest the signature of the transferor or the transferee or the charger or the chargee or the sublessor or the sublessee. If in Sabah, who can do it? Malaysia or Commonwealth, who can do it? Or any other place. Power of attorney. This is one section also you need to know. It talks about when you have a dealing which involves a power of attorney, that you may need to actually have it noted. This is different from Sarawak. In Sarawak, the power of attorney has to be registered on the document of title. And in West Malaysia, the power of attorney has to be registered in the High Court of Malaya, otherwise the power of attorney is invalid. So in West Malaysia, the power of attorney, on the face of it, prima facie, has no effect until it is registered in the High Court. Okay, in Sarawak, if it relates to land, it must be registered against the title which the power of attorney is intended to deal. In Sabah, there's no such requirement. You only need to actually submit it for noting. Just now I mentioned about checking. After presentation, the registrar shall, on examination of the document presented, shall decide whether if it's unfit for registration or defective, he may either refuse registration or return the document for necessary rectification. This is very important because if he rejects this document, you have to re-present it. You present it the second time, you have lost the priority of your first presentation number. Okay? So it's important for you to get your document right the first time. Otherwise, you will lose priority if you have to re-present it after you have made the corrections. If you lose priority and then your client suffer, you are negligent. Okay? Return of title, priority. All memorials shall be numbered serially in order priority of registration. For the purpose of priority, time of presentation shall be taken as a time for registration. Okay? Form of memorandum, as I said just now, memorandum of transfer, charge and sublease is not anybody's invention, it's all in the land ordinance. Proviso for sublease. Any sublease of land granted for a term not exceeding 1 year shall be valid without registration. There are many cases on this because there are some people who sign up tenancy agreement for 3 years, but it's not registered, and then people challenge it that the tenancy is invalid because you must register if it's more than 1 year. The cases have now decided that it may not be registered against under the torrent system, but it is still a good contract in personam between the parties. A divided share, transfer of charged land. If you have charged your land to Maybank, Maybank has gone bankrupt and is taken over by, say, Alliance Bank, Maybank can transfer the charge to Alliance Bank. Why? Because Maybank has an interest in your land. It owns a charge. And because it owns an interest, that interest can be transferred. Okay? Just as you can also transfer a sublease. I don't need to go through all this. I now come to the land rules. The land rules, you must get a copy of these land rules, because I think there are at least 2 questions which involve the land rules. Okay, I'll come to that. You must actually know what is in the land rules. Land rules is actually done also 1930. Rule 2 onwards talks about how you apply for state land. Rule 3 is for temporary occupation license, how you apply for a license. Licenses are normally issued for if you are applying to remove granite stones, or in this case they give an example for guano. Guano is actually the droppings of bags in caves. Townlands, titles under Part 4, native titles, where supposed registration, collection of land revenue, and Rule 8. Services of notices under the land ordinances have to be served in accordance with Rule 8. Rule 8 tells how notice are to be served. Delivering to notice an authorized agent, or if this cannot be found, anyone can accept service, and in final cases you can actually stick the notice on a piece of land. Okay, what I want to focus here is, okay, application for right of way. I mentioned to you just now how you apply for right of way. It's all here. Apply for access for drain. This procedure is if you have breached the conditions of title, like you actually build a shop house on a piece of land which is basically residential land, the government's not happy, they want to resume your land, this is the procedure they will follow. If you really follow, they actually give you a chance to remedy your default. This is if you share a piece of land with your brother or your siblings, and you want to divide it such that each person gets his own title, this is the procedure, or subdivision, or what the land office calls partitioning. Okay? Section 14 is what we want to focus on. Section 14 is the reason why I'm focusing on this is because there are several, I think there's at least one question, there could be one question on this. Okay?